Hello, and welcome to the American Probation and Parole Association's webinar session on enhancing restitution collection and management in probation and parole. My name is Carrie Abner, and I'm a research associate with the American Probation and Parole Association, and I'm really pleased to welcome you to today's session. This is the second webinar in a series on victims' issues in community corrections being delivered by the American Probation and Parole Association through funding from the U.S. Department of Justice Office for Victims of Crime. Today's presentation will be recorded and posted to the APPA website in the coming weeks. I'd like to go over a couple of quick items before we get started with today's discussion. All participants will remain muted for today's discussion to avoid any feedback or background noise. However, we may ask you a few questions throughout the presentation using features of GoToWebinar. To answer any such questions, you may click on the appropriate response on your screen. So let's start with an example question. I'd like to get a sense of who we have here with us today. So I'm going to ask a question about your primary professional work. If you can answer this question on your screen, we'll get a sense of who we have here today. Excellent. Responses are still coming in, but it looks like we primarily have probation professionals with us today, a few parole and pretrial services. We also have quite a few justice-based or public victim advocates, and we also have just a few community-based or private victim advocates. Excellent. So thank you very much for participating on that. Also, if you have a question for our presenters today during the session, you can submit that via the chat feature on this GoToWebinar. Simply type in your question, and we will reserve some time at the end of the presentation to answer any questions that may have been submitted. Also, if you have any technical difficulties accessing today's webinar presentation, including any problems hearing or seeing the presentation, you may also do that through the chat or messaging feature. We will try to answer any kind of technical questions as we are able throughout the presentation, again via chat. Without further ado, I'd like to introduce and welcome today's speakers, Julie Begonia and Michael Cimino. Julie Begonia began her career with the Maricopa County Superior Court in 1981 as a Spanish court interpreter. After working several years there, she joined the staff of the Maricopa County Adult Probation Department, and there she served in a variety of roles, including as a probation officer and supervisor. In 1997, Ms. Begonia began the development and supervision of the Financial Compliance Unit, and in that capacity she developed the policy for enforcement of court-ordered financial sanctions, established a peer education program to aid officers and staff in the enforcement of court-ordered financial sanctions. Ms. Begonia also aided in the development of a budget class for offenders. Following her retirement from Maricopa County Adult Probation Department, she's worked with the Council of State Governments on financial obligations and prisoner reentry. She's also served on the Arizona Commission on Victims in the Courts as a consultant regarding the enforcement of court-ordered financial sanctions and for the Pretrial Services Project in the state of Chihuahua in Mexico. We will also be hearing today from Michael Cimino. Mike currently serves as the Deputy Chief for Administration for Maricopa County Adult Probation in Arizona. Part of this bureau of the department includes the Financial Compliance Unit, which has received national recognition for their innovative approaches to collection of restitution, fines, and fees. The unit employs 14 collectors and 2 supervisors who address financial compliance through traditional collection efforts, as well as resourcing offenders in areas of job skills and employment. During today's discussion, Julie would talk about some of the very practical strategies that any probation, parole, or community corrections professional can use to increase restitution collection, and that's with or without additional resources. Mike will then provide a discussion about broader programmatic efforts that Maricopa County Adult Probation has taken to institutionalize a more proactive approach to restitution collection and management, which serves as an exemplar program for jurisdictions across the country. By the end of today's webinar session, we hope that you will be able to describe the importance of restitution for victims, offenders, and the justice system, identify 2 to 3 techniques to use to increase an offender's likelihood to pay restitution, Describe how the Restitution Court and the FinCom unit of Maricopa County Adult Probation have increased restitution collection in Phoenix, Arizona. We are thrilled to have Julie and Mike here with us today to help present in this webinar session and to talk to us about the role that probation, parole, and other community corrections professionals and agencies can and should be playing to improve restitution collection and enforcement. And with that, I'll turn it over to Julie Begonia. Julie?
Thank you, Carrie. I appreciate that. And good morning and good afternoon to everyone here with us today. I have the opportunity to talk with you about the enforcement of court-ordered restitution payments. And so one of the things that is good about court-ordered restitution payments is it is not rocket science. And should it be rocket science, I certainly would not be the person who would be here talking with you today. So thanks heavens it's not rocket science. When you leave today, you should walk away with some new skills and some techniques that you can employ immediately that will help you with your particular caseload and the enforcement of restitution payments. One of the things we do need to take into account is there is indeed a value of restitution. And when we talk about the value of restitution, we know that one of the primary and principal concept and value of restitution is the financial recompense for victims. It is an attempt for the court to make it sure that the offender can make the victim whole again. And this generally has to do with any kind of financial loss for damage to property or payment for medical expenses. And usually it's limited to those kinds of things. But it is an attempt to make the victim whole. The second thing that we know that it is one of the only tangible proofs or evidence that the offender is being held accountable. And we know from victims that this is an important thing for them. And in many senses, they are gratified by the fact that the offender must think of them, the victim, each and every time they make a payment of their restitution. And so there has a value to the victim as well as a value to the offender. And the final value of restitution is that it helps hold the offender accountable. It allows for the offender to set up short-term goals in making those payments of restitution to make that victim whole. It allows them to develop short-term goal scales and to lead to long-term goal scales. And one of the beauties about restitution and the payment of restitution is it is measurable, and you can see how much you've paid and how much you have to pay. It also provides a teaching opportunity for us to help the offender learn that he or she indeed can later save money for maybe a deposit on an apartment in an area that would be less opportunistic for crime or their participation in crime. Another value that we know about restitution is while it's measurable, there is no relapse in restitution. There may be a hiatus in the payment of the restitution, but we never go back to zero like we do with treatment programs in alcohol and drug. So we're not starting from zero if we should have a stop in payment, but we do know that we can always get them started back on making payments again. Now, as we progress, we do know that there are two measures for success. And those two measures for success are two very easy things that you can employ in your caseload each and every day. One of the things you need to be aware of as well is when you look at your caseload, there are only about 15% of your caseload is actually ordered to owe restitution. And that amount usually ends up being an average of about $3,200, certainly something that can be paid in their probation or parole grant. So the two measures that we can use is to talk about it and to be bothersome. When we talk, the more you talk about payments, the more payments will be made. Every contact that you have with an offender is an opportunity for you to talk about making restitution payments. When will the next payment be made? Praise the offender when he makes a payment. Encourage the offender to set up a situation for himself to be able to make those payments. We know that the more you talk about making payments, the more payments are made. When you make the payment of restitution a priority, then the offender will make it a priority as well. And I can guarantee you that if you fail to address the payment of restitution, That guarantees non-payment of restitution to the victim. The more we talk about it, the more we collect. Also, when I say collect, one of the things we need to stop and think about is when we talk about the payment of restitution, we need to talk about it in terms of collections. When you talk to the offender, say, hey, you're 30 days delinquent in your restitution payment. You're 60 days delinquent in your restitution payment. It makes it more like a real bill that that person has to pay and that is responsible for. The other measure that we use for success is to make it bothersome. We know from professional collections that when it becomes too uncomfortable or bothersome not to pay, then an individual will pay. So we know that if we can make it too uncomfortable for the offender not making his payments, then he will begin making payments. And we can use this by employing intermediate sanctions, and we'll talk about sanctions in just a few minutes. But one of the tricks that is used in collections is just pausing, silence. Nature abhors a vacuum. People don't like it when people stop talking. If you say to an individual, well, what stood in your way of making your payment? Don't say anything else. Let them fill that void. So we do know that we have two measures that we can use, and that leads us to our tip number one. If you treat payment of restitution the way you do any other court-ordered sanction imposed by the court, when you supervise an individual, you'll have success. If you make it a priority, the offender makes it a priority. And should the offender fail to make a payment or make a partial payment, then you need to have quick and necessary follow-up for any missed or partial payments. That responsibility is on you. Also, when we look at tip number two, and that takes us back to talk and bothersome, the two keys for success. Talk about it. Make sure that the offender makes the payment. And when he does make a payment, acknowledge that payment. Give some praise. So for the next time we can do it. If the offender doesn't make a payment, make sure that you emphasize the importance of restitution. Again, making it a priority. Probe for excuses for non-payment. And you can also use the broken record technique. We'll talk about the broken record technique in just a little bit, but let's first progress on to three strategies that we can use that will help us in forcing the payment of restitution. The first one has to do with asking the right questions. The second strategy that we can use is to investigate offenders' assets. And our final and third strategy is to direct limited options. These are three strategies that we'll discuss here that you can readily use with your caseload. The first strategy that we talk about is ask the right question. Now, many times when we're supervising our offenders in parole or probation, we have a tendency to ask them questions, and these are typical questions we all ask them. Why haven't you paid? How much can you pay? When can you pay? I'm sure that all of you have asked these questions. I know that I have when I had caseloads. But what we need to do is we need to make sure that we're asking questions the right way. What happens is we end up asking questions, and how we ask a question, the manner in which it's made, it radically affects the forthcoming answer. So we need to make sure that our questions are asked properly. Don't ever ask a person, why haven't you paid? We need to know that when we start asking questions, we need to hail back and employ the techniques that we use with our offenders in all of our other conditions of probation and parole. Remember your motivational interviewing techniques, any of your reality therapy techniques. Use open-ended questions. Let the offender answer. Remember silence. Let them answer. Don't answer for him or her. Why haven't you made a payment? We don't want to use why. Why is a kind of a question it hails back to our childhood. It solicits excuses. It throws up walls. It gives us vague and non-answers when somebody says, why did you do that? You begin to want to make excuses. So instead of saying why, then say, what stood in your way of making the payment? The offender begins to have to think about solving the problem. And so you say, what stood in your way? The offender has to think about what was it that stood in their way. By using and changing our question from why to what stood in your way, we're actually guiding offenders to start moving toward answers and to solving the problems that they have, making and bringing about their own solutions. Our second way, we say, how much can you pay? We need to change that particular question to how short of a full payment will you be? When we say how much can you pay, we're opening the door to the offender to lowball a payment, usually resulting in a much lower payment than we could have had we phrased the question properly. By phrasing the question properly, it's saying how short of a full payment will you be? In this case, how short of a $100 payment will you be? The result will end up being higher. What happens is the offender has to do the arithmetic. Secondly, there's the embarrassment factor. If you say, if you say how much can you pay, I can pay $15. But if you say how short of a full payment, it's much more embarrassing to say I'll be $85 short. So what happens is we end up getting higher amounts of commitment on part of the offender. So the result ends in a higher payment for our victim. So instead of getting maybe a $10 or $15 payment, when we use how short of a full $100 payment will you be, we're ending up usually with it might be $50 short or $30 short. So we're coming and we're increasing our payment by $40 or $60 simply because we asked the question in a different way. The final question that we ask is, when can you pay? Well, that again solicits a vague issue, a vague time. Oh, when I get paid next week. We have no idea. It's world peace. So what you need to do is you need to ask the person, what day will you bring in your payment? You can also say, what day will you bring in your payment? What time will you bring in your payment? We need to press for specifics for the day and the time. Then hold the offender to that date and time. If they don't show, then you need to do a follow-up call or a follow-up visit with that particular offender. Also, we know that offenders try to get us off track when we're talking with them. They try to get us and skirt the issue of payment. And so what you can do is you can employ the broken record technique. I referred to this a few moments ago. There you see on your screen a dialogue between an offender and an officer. And this is a typical kind of thing that we can employ with a broken record. It's used in sales and in counseling as well to keep people on track. When you use the broken record technique, what you need to do is you need to choose a statement that will be your broken record statement. And then you need to remember that you need to acknowledge whatever problem or whatever stood in the offender's way of making that payment. You need to acknowledge it respectfully, and then you need to repeat your broken record statement. For instance, I understand that your children have been sick, and I'm sorry to hear that, and that I hope they're feeling better. What day will you bring in your payment? Usually when we end up using our broken record technique, we can usually in 4 or 5 statements end up getting a commitment on the part of the offender to choose a date and a time of when they'll be bringing in their payment. That brings us to our next strategy that we can use. We need to investigate our offender's assets. Wake up and smell the coffee, look around and see for real. So what we need to do is when you go, you have the opportunity to make field visits, to visit the offender at home, to visit the offender at his workplace, and to have that particular offender come into the office. So you need to look around. When you look around, you need to take note of what are the assets that the offender has at his home. Does he have a big screen TV? Does he have a new quad out in his front yard? Does he have too many dogs? You need to start taking issue with some of these things and challenge some of these. I had an offenders who've had large televisions, cable televisions, smartphones, and so I had an officer in another jurisdiction said, hey, you know, one of the things I do is my phone has a camera on it, so I just take pictures of them and let them know if need be, I can take and send those pictures to court. So there you have a good idea. Also, notice what the offender's wearing, what kind of clothing, what kind of vehicles they're driving. Question these choices. If an offender is wearing expensive jeans, find out why he's wearing expensive jeans. How about fingernails? That's $50, $75 a month. Expensive athletic shoes. You need to challenge the offender's choices. in what he's spending his disposable income on. One of the ways that we can do this is there's a tool called the Payment Ability Evaluation that was developed in Maricopa County just for this purpose. It's about a 10-page document. The offender is required to fill it out themselves and then bring in the verification. It's bothersome. It's 10 pages. And so generally what it does, it will expose the offender's true expenses and their disposable income. It's a nice way to show offenders that they do have the money and they can make a payment. So that brings us now to tip number 3. As we look at tip number 3, you want to look and you want to question the offender's lifestyle. You want to question all those things that they have in their home and have conversations about them. So question how they're spending their disposable income, and you'll find that you'll get ahead. And while they may not discontinue the cable, they may start making payments. Also, one of the things that we need to often deal with our offenders is sometimes they have difficulty differentiating between wants and needs. And so Maslow was a sociologist, and he determined that man actually had some certain definite needs in order to survive. And those needs in order to survive are food, shelter, and clothing. When a person is placed on probation, the court changes those priorities for the individual, and while they still have a need for food, shelter, and clothing, they also now have an additional need of making court-ordered restitution payments. So instead of Maslow's needs, these are called, as I like to think of them, begonia's needs. So we sometimes need to help direct them and help them determine what indeed are needs and what aren't. That leads us to our other strategy that talks about directing limited options. This allows an offender to participate in the decision, and when the offender participates in the decision, the likelihood of following through on the decision is increased radically. So you can say you can make a payment or, and then insert one of your sanctions. And let's say in this case the payment ability form. You can make a payment or fill out the payment ability form. Let the offender choose which they want to do. The likelihood of their following and changing this behavior will be increased. So you need to stop and consider what are some of the sanctions and what are some of the rewards that you can employ in your caseload to help direct these limited options. We're allowing the offender to choose, but we're telling them exactly which of the two things they can choose from. That leads us to tip number 4. You need to outline and utilize a system of graduated sanctions for your own caseload or for your agency. And the more uncomfortable that you make an offender to pay, the more likely he is to make those payments. And you can use and employ directing limited options to make that discomfort to bring about those payments. So you might take a moment as we're going here today and write down maybe some ideas that you might have about some intermediate sanctions that you might be able to employ in your caseload and with your offenders who owe restitution that would maybe make it uncomfortable enough for them to be able to start making payments. So let's take a look at some of the sanctions that we have here, some ideas for you. And this is a list of some sanctions, and you might frequently reporting. You can make your payment or you can report 2 days a week next week until you make a payment. Or you can make a payment, or you can write a letter to the judge and explain to the judge why you're not making your payments. Those are all make an offender can be uncomfortable. Let them choose. Make a payment or. Now, one of the things we need to remember is we can impose sanctions to make them uncomfortable to make payments, but we also need to issue out rewards. And so have them report lists. Put them on mail-in status if that's a possibility. Do whatever you can. And, oh, by the way, praise an offender for making a payment. Everybody likes to be praised. There are some issues that you can impose in your jurisdictions and others that you can't. So you'll need to choose and decide which ones are available in your jurisdictions. That brings us to tip number 5. Leverage support from other people in your agency. Ask a peer for help. Every agency has some guy in their agency or a gal that's pretty good at enforcing court-ordered financial sanctions and restitution in particular. Sit in with them. Talk to them. Ask help from your supervisor. Sometimes bringing in your supervisor just ups the ante a little bit and makes the payment of a restitution seem even more important to the offender, kind of like having the principal come in. Also, engage the offender's family and or household members, because that disposable income that was previously spent on their household things, that is going to be redirected for restitution, and so these folks need to know what's going on. It doesn't hurt that they know when payments are due, so maybe they can also be a reminder system for you. So let's go on and move on to tip number 6. With tip number 6, the story of the court, it's a paper chase. You need to document everything you do. You need to document every step that you take to elicit payments from your offenders. Should they fail at every step, then you have the ability to prove to the court that they indeed have willful noncompliance of an order of the court. You have your written directives, your payment ability evaluations, attendance at budget class, all your case notes, everything that supports the failure to make payments. Then it's in the hands of the court to determine what to do for a willful noncompliance. I've talked to you today about some measures that you can impose on your own caseload that are of little or no cost at all to you or your agency. By changing how we behave, we can change how offenders behave. Remember to use our 2 measures for success. Talk about it, make it bothersome, not pain. Also, remember to employ our 3 strategies of ask the right questions, investigate the offender's assets, and direct limited options. I hope this will help you today, and here I know that Mike has some other things that he'd like to be able to show you that can be done on an agency basis.
Thank you so much, Julie. We really appreciate this excellent presentation. I'm sure it's providing a lot of ideas and strategies for participants here today. I just want to remind folks, if you have questions for the presenters, please feel free to chat them in during the presentation. And we will be having some time at the end of the presentations to answer some of those questions that have been submitted. And with that, I would like to turn it over to Mike Cimino, who's going to talk a little bit about agency-wide strategies and programs to help enhance restitution collection and management. Mike?
Thank you, Carrie. I want to thank APPA and the Office of Victims of Crime. It's great to be with you and to hear from Julie. I know those are exceptional tips and very practical for us. The 2 main topics to share with you a little bit about that are directly related to what Julie was talking about. The first is our financial compliance unit that functions as our kind of internal collections unit, as well as a program that we've had called Restitution Court. To give you just a little bit of context that some of this exists in, talk to you a little bit about adult probation in Maricopa County. It's a large urban area. We have about 1,000 employees and have a direct population that we supervise of about 22,000 probationers, another 2,000 or so on pretrial release, and then another 1,000 on another 11,000 in compliance monitoring. We prepare a number of pre-sentence reports, as you can see by the graphic on your screen, each year. We serve a county about 4 million citizens, so it's a very large geographic area as well as large in its size. We have strategic goals as a department around crime reduction and service to victims and to the court. And one of the things that's made this very possible is we're fortunate to have dedicated judges that are committed to customer service, which includes the victims themselves. Talk to you a little bit about some of the department's collection efforts. At a department level, we've really tried to emphasize collections as we train new officers and bring them on, and as officers are promoted to supervisors, it's also part of the new supervisor training. Additionally, we try to reinforce the collections efforts, many that Julie spoke with, in the case management of each individual offender as we do the evaluation of that probation officer. So while probation officers are not evaluated on whether or not the offender's payments are current, they are directly evaluated on how the probation officer is appropriately addressing that noncompliance of financial obligations. So those are a couple of examples of our department-wide efforts. Our jurisdiction uses criminal restitution orders, which function as civil judgments, and we'll talk about those briefly as we continue. But basically, it is a civil judgment that is entered in a number of times during the system. It used to be exclusively at the end of the probation grant or the end of a prison sentence, the civil judgment was entered that attaches liens to real property, such as vehicles as well as real estate. Those are recorded by the county recorder's office and then enforced by our county collections department. The legislature has also made provisions that those will be filed when somebody absconds from supervision, and then coming effective in April, the court will have the discretionary option at the time restitution is ordered, in other words, at the front end of sentence, to enter a criminal restitution order for restitution only. Those are a number of times when we use that tool of a criminal restitution order. We also offer budget and job skills classes as the department to the probationers. In terms of giving you a sense of what our overall department collections were just in a given year, those numbers are on your screen, but about $9.7 million of that overall effort was money owed to victims. We do have an internal collections unit of 14 collectors and 2 supervisors. That's the initiative that Julie helped found in our agency and that you'll be hearing about today. It's called the Financial Compliance Unit. And it focuses on financial compliance in a number of ways, but the traditional collections efforts that you heard Julie describe, as well as some of the other things you might think of phone calls and letters and face-to-face meetings and so forth. But they also focus on resourcing probationers with some of the job skills and employment resourcing and things that I'll describe in a minute. That financial compliance unit, by definition, works with folks that are not in compliance with their conditions of probation relative to finances. And these give you the collections numbers from that cases that are involved in that unit alone. So the $3.4 million that you see total and 1.1 in restitution, almost 1.2, is directly from cases that the financial compliance unit is affiliated with and engaged in for people that are not paying. And so they're still able to get payment out of these individuals, which goes to just further Julie's presentation that as we focus on these things, we can get payment out of these individuals. Talk a little bit more specifically about the internal collections unit, the financial compliance unit. There's a number of strategies they use. One of those is to engage in a monthly meeting between the financial compliance unit supervisors and then a probation officer representative from every unit in the department. During these environments, they discuss a variety of, these are relatively brief encounters, maybe 30 minutes or so, sometimes an hour, to provide the probation officers a direct sense of where our collection efforts stand as a department, how are we doing, as well as to resource them, keep them up to date on different programs that are available, resources that are available, different tools and techniques they can use to enhance compliance with those conditions. So that monthly meeting is also functions largely to keep awareness appropriately on collections, that while we are rightly focused on a number of evidence-based practices and looking at effective case management that reduces recidivism, we also want officers to not lose sight of their role in enforcing financial compliance. And that's part of what that meeting is designed to do. They bring different agencies in, whether it's on financial education or different employment resources that are out there. The collectors collaborate with other government entities, whether it's our clerk's office, which receipts all of our payments and keeps track of the balances that are due, or working with the county collections unit that is engaged typically after probation with those criminal restitution orders. We've talked about how they can implement traditional collections techniques, and as well as the ones that Julie has focused us on and given us great practical tips on. They also serve the probation officers in really whatever capacity they can. We try to let them know that they're service-oriented in the sense that their position is supporting the efforts made on that caseload, specifically, obviously, to financial compliance. So if they need help reading a payment history that can demonstrate where payments have gone and what payments have been made, if they need assistance pulling that or reading that, they'll assist the probation officers. They'll also resource the probationers. They'll look at help with job skills issues, or they'll look at their ability to complete that resume. I think often as officers and other professionals, we've interacted with probationers frustrated that they won't find work, only to realize exactly why they're not finding work. Could be limitations, whether it's in literacy or navigating a hiring process that's online, or filling a job application out completely. Those are some of the things that they will look for in addition to the efforts we've described. They often keep track of different job leads, people that are hiring, ex-offenders, and those kinds of activities. So they really try to resource probationers as well as engage in those proven methods that we've seen effective through just traditional collections, but really trying to take a both-and approach. That's a high-level kind of overview of the Financial Compliance Unit, but the other thing we wanted to talk about was Restitution Court. It's a program that's received a lot of attention, and to start at the beginning is where it found its basis and authority in legislation. The Arizona Revised Statutes is our statewide statutory authority, abbreviated as ARS, and you see that on your screen. In the law that they're using, notes that the court, on its own motion, can require the defendant to show cause why the defendant's default should not be treated as contempt, and they can issue a warrant for arrest for the defendant's appearance. So what does that mean on a practical level? What that means is that they're treating the non-payment of restitution as failure to abide by a court order, the order to pay. And they then have sanctions and inability to intervene with that non-compliance because the defendant is now in contempt of court, just as you can be in contempt of any court order if you don't follow it. Which brings us to one of our poll questions that Carrie introduced at the beginning. And I think you'll be seeing that on your screen if you take a minute to make a selection. The question is around, is there similar legislation in your jurisdiction that would allow a court to hold the defendant in contempt for non-compliance with restitution? So if you would, take a minute and make that selection, and we can see what those results are. What this does in our jurisdiction is enable, so if you just want to click yes, no, or unsure, what this enables us to be able to do in our jurisdiction is for the court and the probationer really one-on-one to address, is this person in willful noncompliance? That's some of the terminology that Julie had even used in her presentation.
Mike, this is Carrie, and I'm just wanted to provide the results of the poll. It looks like about 44 participants are responding that they do have such legislation in their own jurisdictions. About 15% report that they do not, and about 42% are unsure at this point. So thank you, everyone, for your participation.
For those results. That's excellent. So a number of us are already aware that we have this capability in our local jurisdictions that we're from. And I'd encourage you to look at it more. What the court did in this program was to simply use existing civil contempt statutes and apply them to restitution that had been ordered. In order to select these cases, because the issue is willful noncompliance, there's a number of criteria that we would look at. We would look at the number of months the defendant was delinquent, the type and number of victims that they had, what extent was the delinquency, both in the amount that was owed as well as the overall amount that was owed of restitution. We'll look at other factors of their cooperations with the collections unit, not cooperations in the sense that they were pleasant, but that they were attempting to pay. And we would also look at the type of offense for which they were on probation. So we're really trying to screen out for the court those cases that were beginning to be initially non-compliant. We certainly didn't bring cases that the individual is mentally ill or disabled and therefore has no significant ability to pay. We were really trying to focus on those cases that were already engaged in the financial compliance unit that were simply not paying, kind of our worst of the worst non-payers. To give you a bit of a sense of the process, having talked about the criteria, we would, if you start at the top of the screen by identifying those cases for restitution court, once we made that identification and felt like we could demonstrate for the court that they are in willful noncompliance, they would then be placed on the calendar, and in order to show cause a hearing was prepared, and an order to appear was given to the probation officer, who would then serve that probationer with the order to appear. Following that service, there would be an enforcement hearing, and with very few exceptions, restitution was paid. I'm going to talk to you a little bit more about, well, what did they do in that hearing? What did the hearing consist of that seemed to gain such compliance from this probationer? The main purpose of the hearing, again, is for the court to make a determination if this person has willfully failed to pay or intentionally refused to make a good faith effort to obtain the monies for payment. If that finding is made, and it pretty much without exception was, as those were the types of cases we were attempting to identify for the court would make a finding of contempt, and there would be a number of options. They could set a future court date after that initial hearing and set some agreements that would attempt to resolve the delinquency. They could, if they so chose, either at that time or a future time, to incarcerate the probationer, and they would often set a purge amount in order for the civil contempt order to be satisfied, and that amount was generally the amount that they were delinquent on restitution. And I know if one of the judges were with me on the panel today, he would note that miracles happened in his court every day, as money would appear with just about within 24 hours, and the individual would be out of custody because the restitution delinquency had been resolved in full. The other option at that initial time that they had was to schedule a future review hearing, and it just depended on the type of case and what had gone on in terms of what the court would do. A little bit about the court's calendaring process and how this kind of strategically worked. The court would call these matters. There would be about one calendar, one morning every month that they would set aside for one of these calendars. It expanded initially to 3 judges when it was up at its height, until we felt like we could demonstrate for the court that we're having success, the court is having success, and we would benefit from a broader capacity. And so the court was so supportive that they decentralized that program. It started with 1 judge in September of 2008 and expanded to up to 3 judges. They decentralized that across the entire criminal bench and modified our existing process of notifying the court of a restitution delinquency. They modified that to allow us to recommend an order to show cause hearing in that judge's division. So we've moved from a program model of 3 judges to a model across the criminal bench where every single judicial officer could take that vested interest in restitution enforcement by having an order to show cause hearing in their courtroom. That kind of tapped into an existing process where we, by administrative order of our Supreme Court, have long since been required to notify the court when the probationer is 2 months delinquent in restitution. Such was the case here. We used that process then in that notification to say, Judge, here's what's gone on. The probation department would recommend an order to show cause hearing be held based on the defendant's willful noncompliance. For the purpose of this program, our presentation, that's where we ended up, and that's how we're operating today. It's easier to talk about how these cases were handled when we had 3 judges doing these individually and exclusively. The cases would be called in a very intentional order. What is meant by that is that the court would often call somebody who would be graduating from the program, so to speak, someone who had demonstrated that they are current on their financial obligation for restitution and that they had maintained that current status over time. And so the court would call first those people who were in full compliance, congratulate them, and exit them out of the program. They would no longer be required to continue to come down to court. I mentioned that Maricopa County is a large urban area, very large geographically, not the most convenient thing. Julie indicated one of those strategies being bothersome, not the most convenient thing to drive downtown, park, and come to court. The second type of case that would be called, though, would be that worst of the worst probationer that was on the calendar for that day. Often the court would select someone that they believed, based on the information we were providing in advance of the hearing, was most likely going to go into custody. They would call the case, the court would ask questions of the defendant, and if a finding of contempt was made, they were immediately asked to have a seat in the jury box, and the sheriff's office would place them in custody at that time. The court has noted that in doing so, in calling these cases in this order, it certainly made the rest of the morning calendar go very smoothly, and people were very took the restitution delinquency with the appropriate seriousness that it deserved. Everybody in our fiscal climate is concerned with cost, and rightly so. The cost was very minimal as we tried wherever we could to tap into existing resources. So there was no counsel that was present or appointed. And that's really a determination for the court to determine their comfort. But the thinking was that this is an issue of contempt. This is not a probation violation matter. It's not a revocation arraignment. This is the sole purpose in this matter is to determine if the person is in willful noncompliance of paying their restitution. It used existing resources in the sense of there was already legislation on the books. The statute I showed you was already in place. We had existing judges and court staff and facilities. As we've decentralized, it's even more tapping in even more so to existing resources in that there are already morning calendars going on changes of pleas and status conferences and so forth. This is simply another type of matter that's called in the midst of that morning calendar by the judge in the division that sentenced the individual to begin with. The collections unit was already providing the information to the court, and they were, instead of this being one more thing that they were adding on the collections unit plate, it was giving them one more tool on cases that they were appropriately challenged with. Also, by using probation officers to serve the probationer with a notice to appear, they were already present, they were already engaged in that case trying to enforce those conditions. To give you a little bit about the results, on the next slide there is a breakdown, and you'll see as we grew to those 3 judges, it really jumped up there. And I think the thing that's important to remember is that these were chronic non-payers, our worst of the worst offenders. We were able to collect over $1 million in money owed to victims from these chronic non-payers, which again just affirms the presentation that Julie gave, that as we place an appropriate emphasis on collections, we will see compliance out there, and we'll see movement and growth, which I think all of us would readily see as our primary function in this area is to help the victims get back what was rightfully theirs in the beginning. And I think when we're able to address that, all of us have been engaged in work then that we were hired to do, and there's a great reward that comes with that. I think with that, we wanted to open it up for questions and learn from you all as well.
Thank you so much. Thank you so much, Mike. We do want to open it up for some questions, and we have received several questions through the presentation. So I'll start with just a few, and I'll throw these out here. One of the questions that we have received is that there are a lot of people out of work these days. How do we collect when someone is on social services and uses lack of employment as a reason that they are unable to pay? Julie or Mike, do you have any response to this question?
I'll be happy to address that particular issue. I know a lot of times we need to challenge offenders to seriously look for work, but there are indeed occasions when they can't find work. So sometimes it's important to help your offender take a trip through his garage. I know I've had officers in the past that have helped offenders set up and get motivated to have a garage sale, and then have the proceeds of that garage sale be directed for restitution payments. Another really handy thing to do, particularly at this time of year, is if an individual is making their income, they're paying their income taxes for the year, then what they might want to do is look at that refund that they'll be getting and that could be directed for restitution. We have a lot of individuals who may have worked part of the time last year. They may not bother to file taxes, not knowing that they do have a refund coming to them, and so that might be something you might want to encourage them to do as well. But sometimes you just have to sit down and kind of brainstorm with your particular offender to find out what you can do or what he or she can do to raise some revenue to pay restitution.
Thank you.
Yeah, I think that's. I think that's great. And
okay, thank you.
Carrie. I think Julie mentioned the taxes, and I think I probably neglected to mention our tax intercept program. It's one of the ways that we can be creative as we tap into those existing. For us, it's state tax refunds. I think we were able to collect almost $900,000 last year just in that program. But that's where working with the offender on both sides, the collection techniques, the creative, like a garage sale, helping them think outside the box. Well, there's day labor you could do. There's a variety of other informal work that you could do in the interim while you look for permanent work that would, again, make some effort toward compliance.
Thank you, Mike and Julie. I appreciate those are excellent responses. A second question that we've received is from a victim services provider who works within a prosecuting attorney's office, and they work closely with victims throughout the criminal case. She says that she gets restitution ordered and it goes to the local probation office. When victims don't receive their restitution payments, they contact this victim service provider because they are familiar with her. It's obvious that our probation office does not make victim restitution a priority for offenders. How can this person address the problem with the probation office? This person says they routinely write letters to the supervisors following numerous complaints from victims regarding lack of restitution payments, but they do not receive feedback from those probation supervisors. So what are some tips that you might be able to provide to help this victim service provider within the prosecuting attorney's office get probation to buy into the whole restitution collection?
I think one thing that comes to mind, if it's really a systemic issue, and I would be careful to make that assumption, but she or he would know based on what they're seeing, then I think that goes to leadership, and I would look for an opportunity to engage leadership, whether it's her doing that or maybe there's someone else in her organization that would be most appropriate. I can tell you as an administrator, kind of being in that world, I would certainly want to know if there was a perception out there that we had work or growth to do in the area of taking restitution seriously. So I think if it's systemic, you would want to engage leadership or see who in your agency would be appropriate to engage leadership of the probation department. Or if it's individualized, then I think helping probation officers who are well-intentioned and hardworking, oftentimes having them get a sense of some empathy of what that victim has been through, that it may have been 1 or 2 years since the original criminal incident. Now it's the person was granted probation, and to the victim that feels like a slap on the wrist, and then the person is still not paying, and helping the probation officer to see why they're so frustrated and walking them through the timeline. I think sometimes as officers we need to be slowed down and reminded of having appropriate empathy for what a victim has been through.
Just a quick follow-up on Mike's comments. You do need to engage the leadership of the probation and parole departments. But one of the things we need to remember is the probation and parole officer are the last advocates for the victim. We need to remember we are advocates for the victim, and we need to maybe have an education component for the probation parole officers for them to realize that. And then they have to remember the victim lost those damages and all at once, and the offender has the luxury of paying it back over time.
Thank you, both Mike and Julie, for those comments. We have one question here for Mike specifically, and this question is, what percentage of restitution that was ordered was the $9.7 million collected? So the $9.7 million that was collected by your unit last year, what percentage or proportion of that out of the total that was ordered?
Sure, no, it's a good question. Unfortunately, I don't have the exact data on that. We have some limitations in what we're capturing through our record management system. So I don't. It's a great question. I don't have the denominator of the to give you a good percentage.
Just as a side comment, one of the ways you might be able to measure that in your own jurisdiction for the person asking the question is how many of those offenders who owe restitution are successfully completing probation, having paid that restitution. A lot of times, as Mike said, we're limited by the systems and oftentimes with the clerk of the court and their systems in order to be able to measure those.
Right.
Thank you. We've got time for one or two more questions. I have one here. We have heard today about restitution court and work with probationers in particular. How has anyone, or is there a jurisdiction that's applying these techniques with parolees who are no longer under the control of the court, but rather under the control of the paroling authority within that jurisdiction? Are either of you familiar with any jurisdictions that are applying these techniques within a parole setting in particular?
I do happen to know for a fact that in Kentucky, I did a training this past year with the parole department, and we did a training and talked about payment of restitution from parolees. And having done that particular training, those parole officers went back and examined what they were able to do, and indeed were able to take out some of our ideas and direct those to ensure that the parolees are making their restitution payments. We even worked with parole officers that were institutional parole officers readying offenders and getting ready to be placed on parole. And they even took measures that they could put into place with a parolee.
Great. And just as an add-on to that, to Julie's response, in that same training series that was conducted this summer that Julie is referring to in Kentucky, we also did some training in Kansas. And as a result of that training in Kansas, parole officers and actually the parole agency there in Kansas is starting to institutionalize some of the strategies that were discussed today. So we are starting to see that, although which is very exciting. It's a little bit newer in parole than it is for probation. One final question for our presenters today is, where can we find additional information about restitution and some of the programmatic efforts that we can implement to enhance restitution collection in our own jurisdictions?
Well, I guess, gosh, Carrie, I would look at some of the APPA fact sheets and some of the other resources. I'm saying that tongue-in-cheek. I know you're going to be sharing some of those sheets and all that. We'd be happy to, in addition to those, if those have questions, I think our contact information is going to be available. But if there's something we can do to share what we've done and others can learn from it, we'd be happy to do that.
Certainly, I know that in the past we have shared information in other presentations that we have done with APPA, payment ability evaluations, the curriculum for budget class, any other kind of some tips and techniques. Those are all available either through APPA or through Mike or myself.
Excellent. Thank you so much for those responses, Julie and Mike. One additional resource that I might also recommend if individuals are interested in learning more about restitution and how they can increase restitution within their collection and management in their own jurisdictions. The National Center for Victims of Crime recently came out with a report called Making Restitution Real. That is available for download online. And one of the programs that it highlights is the program, the Restitution Court and Financial Compliance Unit of Maricopa County. So, but it also takes a look at, I believe, 4 other jurisdictions in the country that are really doing some innovative work around restitution collection. So I would encourage you to check that report out as well. Before we finish up today, I would like to take a few moments to just talk about some of the resources that APPA does have available. Mike just referenced one series of resources that I'm glad he highlighted, and I would like to take a moment to announce to the participants today. Through our cooperative agreement with the Office for Victims of Crime, we've been able to develop a number of resources to assist probation, parole, and other community corrections professionals to better serve those who have been victimized by crime. So one of the first series of resources that we've developed is a series of 8 fact sheets on a range of topics related to victims' rights and needs throughout the community corrections process. This fact sheet series will be available for download on the APPA website within the next few weeks. So I would encourage you to check the APPA website in the near future to be able to download these fact sheets. In addition, we've also been able to develop a training curriculum which includes both a 1-hour online training program on the role of community corrections and victim services, as well as a curriculum package for a 2-day classroom-based training program covering such topics as communicating with victims of crime, incorporating victim input in the community corrections process, victim notification, and restitution management enforcement. This curriculum package will also be available in the very near future, so please let me know if that would be of interest to you or your jurisdiction. And following today's webinar session, APPA will present an additional webinar, the third in this series of 3, on when the offender is a victim, community corrections response to prison rape, on Wednesday, February the 27th from 2 to 3 p.m. Eastern Time. So I hope you'll mark your calendars and be able to join us for that discussion as well. Also to remind you that this webinar session, as well as a previous webinar session that we did a couple of weeks ago, these are being recorded and will be posted to the APPA website in the very near future. Finally, I'd like to let you know about some other products and resources available through APPA and other agencies on victim services and community corrections, including a number of products that we've developed on domestic violence, victim services and reentry, and a few other topics. You can find all of this on our website, which is www.appa-net.org. Also, the Office for Victims of Crime has a wealth of information, including a national directory of victim services on their website, which is www.obc.gov. So I just really encourage you to check these sites out. Finally, the APPA about 20 years ago developed a Victims Issues Committee because we recognized that the needs and concerns of victims are so integral to the work that we do in probation, parole, and other community correction settings. If you would be interested in participating in this committee, we would be glad to have you on board. So you can contact me for more information about becoming a part of that committee. And with that, I just want to thank our presenters for the excellent information that they have shared with us today. You see there their contact information as well as my email address. Please let us know if you have any questions about the information that was presented today, or you can always contact me if you would like to receive copies of the PowerPoint presentation from today or any other resources that were mentioned. And also, I would like to thank the Office for Victims of Crime for making today's session possible. So with that, I'd like to adjourn this afternoon's discussion. Thank you so much for your participation.